Welcome to The Paradigm Shift on 4ZZZ 102.1, where we challenge the assumptions of our current society to resist oppression and investigate alternative ways of living for a world based on justice, solidarity and sustainability. Welcome to The Paradigm Shift on 4ZZZ 102.1 FM. It is your local community radio station. My name is Andy and I'll be here for the next hour. We are broadcasting on Yagara and Turrbal country, and this week I am not in the studio. I'm otherwise occupied, and so I'm sending in a classic Paradigm Shift episode going all the way back to 2019, when I had actually been out of town for quite a long time, and I popped back into Brisbane and I made this episode about SLAPP suits, strategic lawsuits against public participation, which is when corporations sue activists in the civil courts to try to hinder campaigns against them and scare people away from taking action. At the time, there was a suit going on involving a few young people in Brisbane, and I made this show wanting to support them. A few years down the track, I can report that that suit, after dragging on in the courts for a number of years, like most of these suits, did end, like most of them do, sort of fizzling out. Once the campaign had kind of lost its steam, the people being sued were just forced to sign an undertaking saying they wouldn't stop any more coal trains, and that was it. Of course, since then, there's been quite a prominent SLAPP suit as well, which is still ongoing, which was Ben Penning's, a climate activist here in Brisbane, being sued by Adani. And so it's a topic with ongoing relevance, but for now, I hope you enjoy this classic episode. Today on the show, we have a packed show which I'm quite excited about, actually. Today we're going to be talking about strategic lawsuits against public participation, aka SLAPP suits. Historically, a way corporations have shut down protest or public discussion by taking people to court privately, and we're going to be looking at a few different examples of it. There is one current example, and I will speak later on to Sadie Jones, who is being sued by Aurizon, the freight company. She's one of a number of people who have stopped coal trains, Aurizon coal trains heading to ports, and they're being sued. We'll find out more about that. But we also have a couple of other recent Australian examples of Adam Burling, who was one of the Guns 20, a group of people sued by Tasmanian woodchipping company Guns. And that suit went for a long time. We'll hear all about that. And also Shae Anderson, who was sued by McDonalds, who have famously been lawsuit happy in the past. He was part of a group down in Victoria who was trying to stop a McDonald's being built in the Dandenong Ranges and was taken to court. And we also have Greg Ogle, a bit of a bush lawyer, talking about SLAPP suits and why they're a problem. I think part of the motivation of doing this show is to get people talking about the way companies use lawsuits and hopefully get people supporting the Aurizon 5 in court who just want a safe planet, you know. They were just trying to use established means of protest to try to bring attention to climate change and get public acting, and now finding themselves facing bankruptcy up against a company with profits last year of $900 million. These are young people, idealistic people, and so the hope is to support them. And we have a lot to fit in the show, and so we might start off with Greg Ogle. There is a website you can find online. It's the Bush Lawyer's Guide to Being Sued. and it was put together by Greg Ogle, who was involved in several SLAPP suits, and we'll hear a bit more about it from him.
So I'm Greg Ogle, and I've a fairly long history involved in SLAPP suits from beginning when the Conservation Council of South Australia was sued over the High Marsh Island Bridge dispute, and then working for the Wilderness Society and defending the Guns 20 over the Tasmanian forest.
So today we're talking about SLAPP suits, strategic lawsuits against public participation. Can you first off give us a bit of an overview of what do we mean by this?
Yeah, the term SLAPP suit is actually an American term that's been around for 20 or 30 years now, but it's largely when litigation has the effect of impacting on community groups and on protest and having a chilling effect on public debate and silencing people as they become afraid to speak out for fear of being sued. And this is quite different from the criminal law. This is actually developers, businesses, people who are the subject of a protest actually then going to the courts and taking actions, usually for either something that was said, for defamation, or interference with contracts or interference with their business, or there's a number of courses of action. But basically arguing that your behaviour was unlawful because you cost them money, and that can drag people through the courts for years and years, and the penalties are often way out of proportion to the act or what was said. So it really can have a chilling effect on public debate.
So people do get sued all the time for defamation or for interfering with contracts. Like, what specifically makes something a SLAPP suit or makes something a bad effect on public debate?
Yeah, it's a good question. I think for me the key is what's the impact on the person and who's being sued and the campaign that they're engaged in. Because yes, every Hollywood star has run a defamation case. Many politicians run defamation cases, but it's quite different if you're actually engaged in a public campaign, an act of public participation, and as a result of what is often quite normal political activity and discourse, you randomly find yourself sued. That randomness often is actually part of the chilling effect, because you just don't know when it's going to happen. And then all the people around you and in that campaign might then start to second guess what they're allowed to do and what they should be doing. And sometimes they just stop doing this sort of democratic participation because they're concerned that they'll end up in court too.
So are there concerns about the effect a SLAPP suit has on, say, freedom of speech and democratic processes?
Yeah, absolutely. That's the key. It is the impact it has on democratic processes. And in a sense, what you've got is the commercial entity taking somebody to court because they will claim they have some commercial right or a right in property and in reputation. So they're asserting that commercial right over your right to protest or raise concerns in a democracy. And unfortunately, the law tends to recognise those sort of property rights much more strongly and over the top of those democratic rights.
Yeah, so this is an interesting aspect, is to talk about the legality of SLAPP suits. Obviously, it's within the power of the law to sue people in this way, but is it within the spirit of the law?
It's actually quite a contentious question, that one, because some people have actually been sued for referring to these sorts of lawsuits as SLAPP suits, because it was viewed that they were saying that the people were abusing the spirit of the law or abusing the law. So it's quite contentious. I don't take that reading at all. I just think what's important here is the impact the lawsuits can have on public participation and on democratic rights.
There have been moves in different places to create laws to stop SLAPP suits taking place. I understand that the ACT has a law against it, and Tasmania changed its libel laws after the Guns 20 case. Are there other examples of governments trying to stop SLAPP suits from happening?
The biggest change was probably the introduction of uniform defamation laws across all states and territories in, I think, 2006, somewhere around there. And that remove the right of corporations to sue for defamation, so that if you say something about, an oil company, for instance, they can't sue for defamation. That's actually been a really big step to protect the rights of people to protest and to speak out. But it's not foolproof, because individuals within that company can argue that it identified them, or the companies can sue for different alleged wrongs. But defamation used to be the easiest SLAPP suit to run, and so taking that away from corporations has been a really positive step. Small businesses can still sue, and not-for-profit organisations can still sue for defamation. So again, it's not universal, but that's the biggest step. The ACT, separate to that, also introduced a sort of anti-SLAPP law. It's got a really good definition of public participation about what we're trying to defend, but it's a bit flawed, because it requires you to prove that the other side is acting maliciously in their prosecution of the case, rather than just proving that the case is actually against public participation, because it's very hard to prove what's motivating the other side. And the ACT law is probably not very effectual, because you would have to prove that the other side isn't just asserting their commercial rights, they're actually trying to silence you, and that's hard to prove. Whereas it's much easier to go, this is actually silencing me, regardless of their intention.
So are there better solutions that could be put in place to stop SLAPP suits being used?
I think there's much stronger laws that are possible, and certainly work I've done has pointed to draft legislation, which builds on the ACT law, because it's got a good definition as a starting point. But effectively, those laws that have been developed by a number of people in the community sector essentially take that act of public participation and go, if you can go to court and say that, and you can prove that this is a genuine act of public participation, you're not acting maliciously, recklessly indifferent to truth or damage, if it's a genuine act of public participation, the lawsuit should just be struck out. That's as powerful as it gets. And in America, where a lot of this litigation started, there's a whole range of states that have very different types of anti-SLAPP legislation, but it's at its strongest, it simply allows you to get the case thrown out very early on, so you're not tied up in court for years, spending thousands and hundreds of thousands of dollars. If you can go at the first stage and just go, this was an act of public participation, this case should be thrown out. If you can do that early on, it would stop SLAPP suits pretty quickly.
So as somebody who's been involved in SLAPP suits in the past, is there any advice you can give to people, say the 5 people being sued by Aurizon currently, who find themselves in that situation?
I'm not a lawyer as such. I spent a lot of years in court representing organisations I worked for and was an activist with, and I coordinated the defences with lawyers. So my advice is political, not legal. And it's about being careful, knowing your facts, being able to prove your facts, not just that you heard it from somewhere, but being confident you can prove what you're saying, being quite controlled and planned in your actions, so you're not causing unintended consequences, and being strong in your right to protest. Because at the end of the day, the worst thing we can do is stop protesting the things that are wrong with the world. SLAPP suits they're random, but they're not actually that common when compared with all the political activity that happens. So we really need to just be smart about how to be active. But the most important thing is to keep being active. And if the legal threats do come along, treat them as part of the political equation as well, not as some wholly legal thing that you then have to hand over to a lawyer and hide behind the lawyer. They're just, if the cases are part of the campaign, then you've actually got much more chances of surviving the cases and using the cases effectively in the campaign.
We are talking about SLAPP suits, activists being sued by corporations for protesting and things like that. We heard from Greg Ogle, who is a bit of a bush lawyer, as he calls himself, and has been involved in different SLAPP suits over the years. We're going to hear now, the next couple of interviews are from people who have been intimately involved in SLAPP suits, people who have been sued by corporations. And the first one will be probably the most famous suit of this kind in Australia, the Guns 20 case in Tasmania. I spoke with Adam Burling, who was one of the Guns 20.
My name is Adam Burling, and I'm an environmental activist in Tasmania.
And you were part of what are collectively known as the Guns 20, a group of people sued by the woodchipping company Guns in 2004, who spent 5 years in court. Can you tell us a bit about the background of how this happened?
So Guns targeted 17 individuals in 3 groups through the Victorian Supreme Court. It was classically the style of a SLAPP suit. So they weren't doing this for any other reason but to try and halt these range of activists, from a then senator to a local environment centre to one of the doctors for forests, Dr. Frank Nicholson, from basically doing public campaigns. They were seeking a financial compensation of $6.3 million. And that would have been on top of the costs involved with the litigation, which would have been millions. So they were aiming to not only gag the individuals, but potentially bankrupt them, like people like myself.
And at the time, Guns were in the process of trying to construct a new pulp mill at Bell Bay. Was it linked to this?
The writ was issued just 2 days before the pulp mill went to the federal government for assessment. So there would have been some well-planned efforts to how this was launched. And it was supposed to send not only a message to the individuals that were being sued, but to the wider community that if you stand up, you're going to suffer. You're potentially going to lose your home. You're potentially going to be bankrupt, which will affect you for years. So it was obviously initially anyway, a very well thought out attack plan.
So you mentioned the sum, it was over $6 million. What was the feeling amongst the 20 of you when faced with these consequences?
Look, we had one of the first meetings, I remember quite well, that all of us were around the table, so to speak, at one of the halls in Hobart, and there was a couple of people really despondent, head in their hands, and just really not knowing what to do, because the advice we were getting straight up was that this would take years to resolve, and that a number of us were facing losing everything. So it was a pretty overwhelming. And it was also something that really hadn't been done on this scale in Australia. We, in the end, we ended up getting some briefings from the McLibel too, because they'd been through this, being sued by McDonalds, and so there actually hadn't been activists targeted like this on this scale before. So that was the other thing, just trying to get your head around what we were facing, and it was pretty overwhelming. But I think as it went on, we supported each other, and we started to get a public campaign going, and things began to change.
One of the things that probably backfired on Guns was the fact that there were very high-profile people like Bob Brown and Peg Putt, who was at the time in the Tasmanian Parliament, included in the 20. Did that work to your advantage?
Oh, it definitely did. There was a similar case not long after the writ had been issued called the Tribunal 13, which was targeting other frontline activists, and it had nowhere near the profile that the Guns 20 had. So it was a mistake by Guns, among many in the case. But Senator Brown was an interesting example. The fact he wasn't... I was being sued because of participation in frontline non-violent direct action, trying to halt logging near my home. Whereas Senator Brown was being sued for publicly campaigning. He wasn't being sued for being arrested against guns operations. And Bob had to spend a whole lot of energy just defending himself. And in the end, Guns dropped him from the case. But they only, as part of the law, they can drop you from the case, and they only have to pay you a certain percentage of your legal costs. So he ended up being personally about $70,000 out of pocket in terms of legal fees. So that's what he had to pay just to be in the game, even though the case was completely fabricated against him. So how these lawsuits work is that they basically tie you up in all this legal framework. It expends money and energy, and it's not necessarily meant to get a result for the company. It's just meant to create that chilling effect on the community and to take out the individuals who are being sued.
So, as well as Bob Brown, a number of the other people among the 20 were dropped from the case or settled out of court, and by the time it almost went to trial, by the time the trial date was set more than 5 years later, it was only you and 3 others left. Why did you stay on till the end?
Well, it became a moral issue for me. I went through the ease and troubles of being bankrupt, and I had a small little cabin that my partner and I had built that I would have lost. That it became a struggle that I just couldn't step back from. And it was interesting, towards the end of the case, we had the incredible support of a very large law firm, Herbert Gear and Rundle, and as well as some other pro bono solicitors. And I had some of the best legal advice in the country. And because we had cost guns money in terms of delaying their logging, so the cost of that delay, but we'd also be up for the cost of the litigation. So my share would have been in the hundreds of thousands, if not 1 or 2 million, if I had been taken out. And I was told through some of the best lawyers in the country, I had no chance. If this was to go to court, I would lose for certain. And what I was going to do, though, was I was playing in the public arena. I knew I couldn't win in the legal arena, but I just had to take this on for my own sake and run it in the public arena. And just the day I was prepared, I had everything set up to move over to Melbourne for the month that the trial would happen. And it was the day before the trial was supposed to begin that Guns dropped the case against us. They had to pay us, the last 4 of us, which was Lou Garrity, my neighbour, who's an incredible woman, Brian Dimmick, who's a filmmaker, and then the Huon Valley Environment Centre, the small community group I helped set up. So I had to pay the 4 of us $150,000, and that included, which was unprecedented, about $15,000 each personally. So it was an absolutely David and Goliath win. It was just incredible.
Mm. Over the course of it, and it was 5 years, what was the effect of it on you as a group of activists, and how did you get on through that process?
Well, everyone had to go through this, personally. They had to make their own decisions. And there were some people who just couldn't face going bankrupt. So they settled with Guns. There was a couple of people straight away made agreements that they would not protest anymore, that they'd not go into the gun site. There was a couple of people who paid out with the Guns claim, and I can understand why they chose that. Some of those people weren't being involved in the campaign anymore. So it was tough on everyone, and there were some people who was tougher on others. My very good friend Ben Morrow, he was suffering from stomach cancer. He was being sued as a direct action activist, and he begged Guns all the way through. John Gay personally, he asked to have the case dropped against him, and they refused. His specialists were saying that his situation, his cancer, was being exasperated by the stress of the case. Eventually, he went to court mediation and was dropped from the case, and Guns were forced to pay his cost. But this came at a tragic end for him, because just a few months later he passed away. So it had a huge impact on people, and I think I wouldn't have got through it if it hadn't been for my partner, but also for people like Senator Brown supported me solidly, and my neighbour Lou Garrity, who went through the whole process with me. It was a very tough 4 years, and for almost 5 years, and it would go in waves. there'd be a hearing, and then there'd be a break for a little while, and then there'd be another hearing. So that it came through moments of quite intense periods.
And what about for the campaign to save Tasmania's forests, which is what this was about? What effect did the lawsuit have on that?
Well, I think it actually boosted the profile of the case because we gained international attention for this. And it also just highlighted the brutality of this company and people like John Gay, the director. It showed that how ruthless they were to get power and to make money out of the public forests. So I think in the end, it was a very good thing for the campaign. We've gone on since then to have the World Heritage Area. Many of the forests we fought bitterly over, protected. And the forests of near my home, they were supposed to be 1,000 acres, clear-felled, burned, the native animals poisoned. All of that is still intact because our community stood up against guns. So the campaign, in the end, was a very effective one. And, guns, it probably cost them about $2 million to actually set up the case in terms of the huge document and the extensive allegations they made against the defendants, but then also another few million in terms of paying out some of the cost. So, guns have now disappeared. They've gone bankrupt. So it was a complete disaster for them, and in the end it was a huge win for the environment.
What do you think were the factors that allowed it to be that kind of positive result from something that at the beginning must have felt like it could have been very negative?
Well, one of the things is we organised very quickly. We brought in a solicitor who acted on behalf of all of us in terms of the campaign side and interpreting just some of the basics of the law. Adam Beeson, his name was. He basically acted as a conduit between all the lawyers and to help make legal sense of it and being able to transfer that legal side of things into the public arena. So, Guns made a mistake of suing some of the most effective activists in Australia. And while a few stepped aside, for their own reasons, there was a bunch of us. It just got us together, and we worked very hard on the public profile of the campaign. And that's what the two-pronged attack was, having the support of some of the larger law firms because they realised the potential for this case to create legal history, but also the public campaign side. So it was a two-pronged response to the attack. And we worked very, very hard on the campaign side of things. And we also didn't stop the direct action. The direct action continued. Some of the orgs involved, like the Wilderness Society, stopped direct action. But we wanted to show that we weren't going to be intimidated. And, I think that was part of it, is not stepping back.
All right, thanks very much, Adam. Is there anything else you wanted to add?
I guess just to add that anyone facing these sort of lawsuits, these SLAPP suits, needs to take strength and courage in the fact that we can beat them. We can beat these companies. No matter how much money they have, no matter what legal resources they throw into it, they can be beaten. And they can be beaten in the public arena. No one likes a bully. No one likes attacks on democracy and on free speech. And to have hope that there are many people out there in the community that don't want to see these sort of legal cases occur.
You are on The Paradigm Shift on 4ZZZ 102.1 FM, and we were talking with Adam Burling, who was one of the Guns 20, famously sued by woodchipping company Guns for over $6 million. It was thrown out the day before it was meant to finally go to trial, but quite a remarkable story all up. Let's keep on going. We've got more to go in the show. Another big company, bigger than guns, that has showed a willingness to sue people in the past is McDonald's, and they famously sued a couple of activists. It's been referred to already in the show, the McLibel trial. They also sued some people from Tacoma in the Dandenong Ranges just outside of Melbourne a few years back. One of them was Shae Anderson. Let's have a listen to the story of that.
My name's Shae. I live in Melbourne. I've lived in the hills for 6 years and am now back in suburbia. And I was part of the Tacoma 8 who were sued by McDonald's.
So this was part of a group who were active protesting against a McDonald's being built in Tacoma, which is just east of Melbourne. Can you give us a little bit of background about the campaign first?
So the background is very much local community members. They did all the normal things that you would do as a community, expecting local government to respond to community requests. So they started off by, when they found out that McDonald's was going to be built, they petitioned the local council. The local council heard their petitions, saw that a few of the community wanted the McDonald's, so they said no to the application. McDonald's then went to VCAT, which is the Victorian tribunal which you go to when you want to contest a building permit. And VCAT said yes, they could build a McDonald's, even though the council said no. That's quite common. VCAT will overturn council decisions for developers quite often. At that point, the community realised that the normal channels weren't to work, and their first step was to take over the land and build a garden on it. Dandenong Ranges, hills area, it's a very hill thing to do. They took over the space, they built a garden, and they camped on it for a month with the attempt of saying, we don't want a McDonald's here, we're going to occupy the land. After a month, that was moved on. And then when they got word that McDonald's was going to demolish the buildings that were on the site, several of us occupied the roof while others protested around the buildings. And we occupied the roof space we were there for a couple of weeks. There were other people who were up after we were being sued. So it was around a month and a half, that the roof of the building was occupied so that McDonald's could not demolish the building.
So you mentioned there that you were getting sued, you and 7 others. How did this come about?
Basically, one day, as far as we were concerned, one day we got served with a piece of paper, and the piece of paper said that we had to go to court. That was our experience of it. For McDonald's, I think they'd been thinking through the ways to shut down the campaign for quite a while. Obviously, they'd had 2 different iterations of campaigns against them, so they'd already been, I'm sure, in the background thinking about talking to lawyers about what they could do. But what happened was 8 of us were served with papers saying that we were being sued for damages. But the big thing about the legal proceedings was it wasn't just the 8 of us. It was the 8 of us as representatives of anyone in the community who had done anything that blocked works, which was very non-specific. People weren't really sure. Did that mean people who were on the roof? Did that mean people who may have been holding a sign out the front, or did you have to link arms? No one really knew who was actually being sued, but the legal proceedings meant that McDonald's was basically suing the entire community. They weren't just suing 8 of us, they were suing an unknown number, probably about 50 to 80 could have fallen within what that paperwork said.
And so what was the basis of their legal case? Was it defamation? Was it that you had done illegal activity?
It was that we had cost them money. They were suing for damages. We had done damages in not allowing them to build on the site.
And so you're served with these papers, and obviously there's a potential cost if you break a court injunction. What were the potential consequences of continuing to do the activism once you had been sued?
Look, I suppose the key thing was that the way this legal proceeding worked, and that we were explained from lawyers who supported us, was that if they sued and were awarded an amount of money, hundreds of thousands of dollars seemed quite likely, they could take that whole amount of money off one of the 8. So it wasn't like it was split up between us, and if it's $200,000 awarded, we each get 1/8 of that. Actually, they could say, well, one of you has a house that's worth that amount, we'll take all the money from you. And so what it meant for the 8 of us, and more broadly for the community, those who had any sort of assets felt a real fear that they could lose them. At the time I was renting, my car wasn't worth enough for them to pursue, but I had the fear that if I did something wrong, it could come back on one of the other community members who could lose a house. That was the fear, and there was a definite fear amongst people that could happen. Now, generally, my opinion that wasn't likely to happen, but it's not really very helpful when someone tells you, well, that's not likely to happen when you're talking about the place that you live, something you've probably built up over many years. So there was a real fear amongst particularly the 8 and those who felt like they could really lose something out of it.
There's a famous precedent to this of McDonald's suing activists, what's known as the McLibel trial in the UK in the 90s. There were 2 activists, Helen Steele and David Morris, who wrote a flyer complaining about McDonald's and were sued for libel and went all the way in court, refused to settle, and in the end won. Was that precedent something that you were conscious of at all?
We definitely talked about it. I guess the situation we were in was that we had a large number of people who felt affected by it. So in the end, we did not pursue it as far as they did. Well, we did pursue it, but the court process is that we are required to negotiate before we go back to court and contest it. And in that negotiation process, we came to a point where we could come to an agreement with McDonald's, which impacted the 8 of us, but did not impact the majority of the community, and we settled for that. And the impacts for us were around not being able to go back to that McDonald's. There was no cost associated.
So literally all they won out of the suit was shutting down the ability for the 8 of you to protest?
Well, no, they got a lot more than that, because there was a time frame in which we were all uncertain about what it meant. And in that time frame, that level of fear meant a lot of people did not act. So in the time frame of the court proceedings, the 8 of us chose not to do anything more in terms of disruption to the site. And I think a lot of other people held back as well. For some, that was a tactical thing. We need to focus on the legal proceedings. This is the thing that we can do. But in the time that those legal proceedings were going on, the buildings were being demolished. They were starting work on the site. So it had the effect that McDonald's wanted, which was to be able to build on the site. Really, the amount of money they got out of us was not an issue. The wanting to be able to build on the site was what they were really aiming at.
Obviously, that's a pretty strong effect on the campaign. Did it have other effects on that campaign?
That's a good question. I would say, look, I think the whole process of that campaign took a lot of people from feeling like their local government and the processes that are set up are there to represent them, to realising that actually those processes really benefit large businesses far more than they benefit the average individual. So it was a learning process for the community. I would say a lot of people out of that campaign have become more politically active and more politically aware. It was very much a local community. Many hadn't thought about activism as something that they would get involved in. It just is that McDonald's came to their front doorstep and they acted. But I think it had a long-term effect of really getting a lot of people more active.
Oh, that's a positive thing. Would you say that the lawsuit aided that?
I would say that the lawsuit made people more aware about who the law protected. But having said that, I would also say it, in the short to medium term, it created a lot of fear in people. And I should say one of the other things that the lawsuit had within it was that we were banned from walking down the footpath in front of the site while the proceedings were happening. And that was anyone who the proceedings referred to. So when I said before, it actually referred to maybe 50 people, and people weren't sure if they were covered by this lawsuit really meant them or not, because it was just anyone who'd been involved was covered. So a whole lot of people couldn't walk down a street that they did every day or regularly walk down. They weren't allowed to walk down that street because it went in front of the site. And these proceedings may be referring to them, and they weren't sure and they had no way of knowing. So for a period of time, for months, people actually couldn't walk down a street and cross a major road at the lights. They had to cross it at another point which had no lights. They had to be full of where they went in their own community.
So looking back now, 5 or 6 years down the track, are there things that you would have done differently around this lawsuit?
Look, I think being in the middle of it, it was hard to see how much traction we were actually getting, how well known the campaign was. We were just really busy in doing the work that we were doing. But the level of traction that we were getting, the level of ability to put up a fundraising page and fundraise to send activists to the US, to go to the head offices of McDonald's, or just to get media attention. Looking back and see how well we were doing it, just being visible as a campaign, I think I would encourage people to push harder, I guess, rather than allowing the proceedings to have the effect they did. And that said, I know at the time there is all these thoughts that I mentioned about people losing their houses, afraid of losing their houses, showing solidarity with you fellow campaign members who are actually really afraid, saying, they can only arrest so many of us. They're doing this lawsuit is because we're being effective, and we need to keep being effective. And I think that's something I would, in retrospect, try and do more of.
All right, thanks very much, Shae. Anything else you wanted to add?
Oh, look, I just saying all of that, particularly what I said last. My mind is really on the frontline action and coal activists that are being sued, and I'm really aware that it's really difficult to go up against companies with really deep pockets and really good lawyers. And yeah, hats off to them for what they're doing, and really aware that it's a hard thing, and I hope a lot of people get behind them.
We're talking about SLAPP suits on the Paradigm Shift today, and you did hear mention at the end of that interview with Shae Anderson, who was sued by McDonald's. Shae did reference there the people currently being sued by Aurizon, and I did speak with Sadie Jones, who is one of the Aurizon 5. Let's have a listen to Sadie.
I'm Sadie. I'm one of the Aurizon 5, so I'm currently in a civil court case against Aurizon for blocking their coal trains in November.
To start off with, maybe we should get an idea of why would somebody block a coal train?
So obviously I'm passionate about climate change, and after attending more rallies than you can count, I just really, I chose to take direct action, kind of to show, I guess, Aurizon and to take a stand against the fossil fuel industry as a way of, protesting the incessant export of coal when we're in a climate crisis.
So you blocked a coal train with a cup of tea, no less. You went to court and got charged, like it normally happens with these civil disobedience actions, and that would normally be the end of it. But in this case, you're back in court. How did the lawsuit come about?
Yes, it was a real shock. As you said, you go to court, they dish out a fine or whatever, and then everything just sat quietly for 6 months until I was served in person at my house one evening. A lawyer-type person arrived, waited for me to get home and hands over some documents, and then that's it. You're kind of into it, whether you like it or not. And they have all these claims against you. There are, 72 points in this long document, and everything in that gets addressed over the next however many months, and part of it is asking for $75,000 in damages, which is, I guess, the most important sentence in the whole thing. Like they're trying to bankrupt us. They know we haven't got $75,000.
So there's some pretty serious consequences potentially coming from this. How did it feel when you served with this?
It was shocking. But that very quickly becomes frustration, because I know I haven't done something warranting having everything I own taken away from me, right, or being threatened with jail terms. like I've done a peaceful protest and this response is purely tactical. So what I'm feeling is mostly frustration that corporations have the power to do this, that there are no protections against a company taking individual people to court in this strategic way that's designed to be time-consuming and resource-draining and energy-draining and ultimately financially crippling, basically because they don't like public resistance.
So, involved in this lawsuit, there's yourself and then there's 4 other co-defendants from across the country, as well as the organisation Frontline Action on Coal.
Yeah.
Had you had contact with these other people before?
I had only met one of them briefly, and now we're all tied together by this case, and we're forming long distance bonds, but at the same time you're working with people all around the country, and it's strange and also kind of nice to have that sense of solidarity and know that you're generally feeling similar things, but coming at it from these diverse perspectives, because we have school teachers and volunteers, and I'm a student and things like that, and we're kind of like fumbling our way through it together.
Do you think it's affected your ability to organise against climate change?
It's definitely in the back of your mind, but I guess it definitely hasn't changed anything about the way I feel or what I know needs to happen. It hasn't changed my mind about direct action, definitely not. But it's always in the back of your mind, kind of knowing that you are, you're known by the courts and you're potentially up for a lot of money very soon. It's kind of always a bit, it's just there as a presence.
So today we're doing a show on SLAPP suits, and we talked about a few others. Have you come across these other instances of it happening in Australia?
So when we were first chatting to lawyers, I stuffed my head into journals and archives and the media and this, that and the other, trying to find examples of what was happening to me, and it's incredibly rare in Australia. But the Guns 20 case is the biggest. This huge case drew media attention, heaps of media attention all around the country, and I know you're chatting to people from that, and that was a perfect example of the way these work, but it was also an amazing example of how they can fail, and guns failed in that one. They ended up bankrupt, but it came at a cost, and this is definitely going to come at a cost, whatever happens. So I guess what I learned from reading about that is just that we need legal protections, and there was this huge call after the Guns 20 debacle. There was this huge call around the country for anti-SLAPP legislation, and it just fell flat on its face, and we need to revive that call because it's so important. This wouldn't have been happening if this legislation had passed, back after the Guns 20, if we'd actually, changed the laws, but it's happening again, and so we need to pick it up and call for law reform.
And so this case is ongoing. These things tend to go for a long time.
Yeah. For
you guys, the 5 of you and other people involved, what kind of support do you hope for from people that are sympathetic?
I guess we need people to be talking about this. Part of, the very nature of SLAPP suit is it's an intimidation tactic, and they want to scare you into silence, and they want everything to happen behind closed doors, with men in suits handing things back and forth, and it's all very boring and the public doesn't get a look in. But we need to change that. We need people to know that a corporation is taking 5 individuals to court for like $500,000 in total. We need to know that they're doing this because they're afraid of direct action, and that direct action can't stop, and I guess we just want conversation around SLAPP suits, around what's happening to us, around what needs to happen with the law to stop this ever happening again.
And what do you think will be a good result for you?
A good result would be everything dropped, costs awarded to us, and maybe an actual cup of tea with the Aurizon CEO, but I don't see... I see realistically, I see a long, drawn-out battle with wins and losses along the way.
That is Sadie Jones there, who, when this episode was made in 2019, was being sued by Aurizon. As I said at the start of the show, a few years after that, that lawsuit eventually petered out with an undertaking signed by the plaintiffs of the case that they wouldn't block any more Aurizon coal trains, but the case had its use by then of slowing down those actions, which were gaining a lot of momentum. And of course, the tactic hasn't gone away of corporations suing activists. Neither has the need for us to show solidarity to people who are singled out like that in those cases and support them in the long and arduous legal struggles. That's all we have time for this week. Hope you have enjoyed this classic episode of The Paradigm Shift. I'll see you next week.